Hey, everybody. It's happy noonday. Chuck Cook, Greg Siskis.
I like this early time.
It is. Yeah, you know what? It was impossible to do our call last night. Aaron, why was it impossible to do our call last night?
Well, we were filing a lawsuit. So we were in the midst of that. So we had to push it to today. So we were happy to get it filed. And there's now a lawsuit pending saying that the processing of EAD cards is unlawfully slow.
The Kang case.
Yeah, it's Kang.
We went
v.
Kang,
DHS.
Kang versus DHS, or we go with Kang versus Mayorkas?
I think it's captioned as DHS.
Okay, well, we'll take that. But I love Kang. Thank him for being part of that. I don't know why that went away. But Darren, tell us about this case.
Yeah, so there are two, well, I think probably everybody or a lot of the people tuning in have experienced how long it takes USCIS to issue a simple employment authorization card. And Greg always likes to point out that DHS's own data shows that it takes them 12 minutes of adjudicator's time to do this.
$460 for 12 minutes.
Yeah. So
they make a lot more money than a lawyer does.
And even given that it takes 12 minutes, they, in some categories, in some service centers, they say it's normal processing for it to take 21 months and don't contact us unless it's outside of normal processing times. So what happens during all that time? People lose their jobs. People can't provide for their families. People can't miss employment opportunities.
They can't get driver's licenses.
Can't get their driver's licenses. And these wait times didn't come out of nowhere. There used to actually be a 90-day requirement that they had to issue the EAD or adjudicate the EAD application within 90 days. And if they failed, then you could, at least in theory, the regulations provided that you could get an interim EAD. And that would tide you over until they got the real one. And the interim EAD could be 240 days. Well, in 2017, at the beginning of the year, they made a final rule that said, we're going to do away with this 90-day requirement. But in responding to everybody, commenting and freaking out about what this would mean and all the problems it was going to cause, DHS said, don't worry. We're going to still commit to the 90-day processing timeline. It's just not a requirement, but we're going to do it. And you have all these resources. If 75 days go by, you can contact this USCIS tip line and they'll get your case expedited so that you get it within the 90. Or if you're subject to an automatic extension of 180 days, if you get to the 165-day mark without an approval, you can contact the same tip line and they will get you expedited so that you don't have gaps in employment.
Yeah, the crazy thing about that regulation when it came out was that you really have to hunt through it to see if you can find the reason for getting rid of the 90 days. And there's sort of some vague statement about security as the reason why they were doing it. But they never actually, it was like literally like one line in that whole regulation. They never presented any evidence that there were issues, why they needed more time. And the other kind of crazy thing was they always were delaying EADs on if there were issues that came up and I don't think anybody had any problem if there was a genuine issue that arose that required further investigation. That was never a problem. But they, and I don't think there were any positive comments on that I can recall from anybody. There were thousands of comments from people saying, don't do this. And I don't recall any of them discussing any positive comments saying this was a good idea.
Well, the actual reason for getting rid of it, at least in my opinion, is just that even though they had better processing times then and they had the 90-day requirement, there were still quite a few cases that would fall outside of that. And then at least in where I practice in Denver, we would go to USCIS and say, hey, we need our interim EAD. It's required under the regs. Yeah. And they had no process to give it. So they would get sued and sued and sued. And so I think my opinion, they were just tired of being sued for failing to comply with their regulations. And so they changed them.
For those of us who are really old, the local offices who would issue these temporary cards used to have a machine to make the cards. They literally had a machine and security paper. It's like, it's like going and get your Social Security card laminated. It was just a crappy old laminating machine with the security paper. And you can go and do that. And Obama, actually, I think it was during the Bush administration, they began taking those machines out of the local offices. Because EADs used to only be in the local offices because we're going to go nationwide. We're going to be some, we're all in this.
But I will.
Do you know who the DHS, the USS secretary was who got rid of 90-day EADs? It was Ali Mayorkas. The guy who's now head of DHS.
Yeah.
This was not a Trump idea.
But if you take it a step back further, why do we have EADs?
That's your point on this is exactly correct. Why
we only have EADs because we wanted employers to have we wanted a secure, reliable document that employers could verify somebody was employment authorized. We don't need that anymore. We have E-Verify, we have machine readable passports, we have receipts with barcodes that can be verified. Everything that you get out of an EAD, we already have other systems in place for that. And so now it's just basically a money printing machine for USCIS, the EADs. There's no reason why we need to have them at all anymore. And all the delays that we're experiencing right now are completely unnecessary. Now, some of this Congress would have to change, but there's no good policy reason anymore why we need the EADs. And you don't even see USCIS trying to defend the need for an EAD versus other systems already in place.
I'm sitting there, I'm just thinking, remember when Trump wanted to raise the fees? Weren't they going to reduce the EAD fee a little bit? If I recall correctly, I think it was one of the very few fees they were going to reduce a little bit, because at $3,000 an hour making EADs, which I think is what that number comes out to, then maybe they're charging a little too much to make EADs.
Well, premium processing is coming soon too, so you can tack on. You can make that $3,500 an hour.
$2,500 to get your EAD.
Well, no, they are only going to charge $1,500 for
only $1,500.
$765. And they'll do it in 30 days, not 15.
Oh, what a screaming deal then! Especially if you're making $15 an hour, and you need that job to pay your rent this month, and that $1,500 is more than your rent. I'm super proud of you, Aaron. I thought the complaint is fantastic. We posted it on the Twitter machine.
Yeah, it was.
I want to take a redacted complaint, of course. We have 40 plus plaintiffs, I believe, in the case, and we're going to win this case. Now, we do want to do a shout out to our friends at Banias and Wasden. Or was it Wasden and Banias? I forget which one goes first. I'm sorry. Please forgive me.
Wasden Banias.
Banias. Again, I'm so sorry. Please forgive me. Nobody says cook right either, so I get it. But it looks like they're about to announce a settlement on their H4 and L2 EAD lawsuit.
Right.
At least that's what Lubna Kubli was reporting this morning in the Times of India, a preeminent newspaper in India. And that's great news for all the H4 EADs.
We can. So Lubna mentioned that L2 EADs are going to be incident to status, which is kind of what I was just talking about.
It's always been.
You don't need an EAD. You won't need an EAD as an L2. There's other stuff that's going to be announced, but we can't talk about that yet. But we had to. That was also factoring into who we sued on behalf of last night. There are some groups that are not in our suit last night, and it's not because we weren't interested. It's because this other litigation is covering certain categories, and there will be good news for people in those categories. But we will, after tomorrow, I think we'll, now that we've had a little time to digest what the following of this, announce that we're going to take some more plaintiffs. We get 15, just as sort of as part of litigation education here, we get 15 days where we can amend our case and add plaintiffs really without having to get any kind of permission from the or consent from the Justice Department. So that's why we always add plaintiffs in that short period of time after we file a suit. So look for some news on that coming probably tomorrow.
So that's exciting, and if hopefully we'll fall within their open-mindedness at USCIS now of maybe settling cases before they go to trial. Something our friends at the Department of State have unfortunately not accepted into their bailiwick of processing. So that's the EAD case. Let's talk about a couple of other things that are going on. We learned today, if I am not mistaken, Greg, that Curtis put up that the government has filed a notice of appeal in the Good Luck case.
Yeah.
And that is because the Good Luck case had their final decision was the same day as ours, right? I'm trying to remember, which is the 30th of September. So there was in fact a court order in our case on the 9th of September. By the way, 60 days would have been yesterday because it's 31 days in October. But we haven't gotten an appeal on our case because I think the appeal is not due until the 30th because of you appeal final judgments. You don't appeal interim judgments.
Mm-hmm.
And something that's interesting, we know that they told Curtis they wanted to appeal in some pleading or some communication, and they needed permission from the Solicitor General. But we have had no such communication. I don't know. I still don't know if they're going to appeal. I would expect that they will, which is fine. We'll win on appeal too.
They may be looking at what Congress is doing.
Yeah.
They'll know before the deadline whether the parliamentarian's going to let that language in, and
if they ever give the language to the parliamentarian.
I think the difference is even though it came in one order, that September 9th order, for the Good Luck case, that was a PI. So that was an appealable decision. For our case, it wasn't the final judgment. The final judgment came on the 30th.
Yeah, so we went right to the final judgment in the case. So they've got a little bit of time, and we'll see. But here's the thing. Even if they appeal, that's okay. They can appeal all they want. They still have to obey the judgment unless they get a stay from the court. And of course, we'll oppose any stay. Frankly, I don't care if they appeal. As long as they process our clients' visas, they can appeal all they want.
Right.
And of course, they haven't. As far as we know, I don't think they've processed any of our plaintiffs yet.
No.
I'm aware of. They have asked for some information. We haven't processed anybody. Same is true, by the way, for Gomez. They haven't processed, as far as I know, anybody for DB 2020. But they would need to seek a stay. And certainly Judge Maida is not going to give them a stay on that case. And I'm not sure that the circuit court would give a stay on that case. Greg, you did mention, by the way, that Congress has added a recapture provision to recapture.
There's a special one for DV,
yes,
which is a really great provision in there. It's not just covering DV 20 and 21, but it covers DV 17 onwards. Basically, folks that, some of the folks that didn't get visas because of the Muslim ban. I don't know the figures from DV 17 and 18 and 19 as far as how many didn't get used, but my guess is there were probably a decent number, probably at least cover those folks. And then for 20 and 21, they're covered as well. But basically, all the numbers that we've been urging the judge to come up with as large a number as possible. But under the legislation, if it passes, all the numbers get reclaimed, not just the the numbers that are in these judgments. So obviously, we're rooting for Congress to make our case moot. And that because that would be good for everybody.
It would be interesting, Greg. Would it actually mute our case or not? I think, in fact, the judgment, they would still have to get that third of our plaintiffs get them visas. It's the ones who wouldn't be getting visas that now have that opportunity to get them. So I still think
I think you're right about that. Although I would be surprised if the government didn't try and argue to moot out our case based on legislation. But we'll see. Also, I think that the legislation, I have to look back, the effective date may be out like several months.
6 months. It's 6 months out. Now, the other thing on that process is, it's just concerning that this in order to appeal, by the way, in order to appeal a judgment in immigration, you have to get permission from the Solicitor General on a case like that, on this type of mass action thingy. The government, if it's just a regular old case, they don't necessarily have to appeal. But generally, they need permission from the head person, the Solicitor General who represents the United States in federal court. It's not the Attorney General, but the Solicitor General. And they gave permission for that appeal. Greg, what is going on in the White House? Does Susan Rice have that much power?
Honestly, I think that I don't think in a lot of these cases the immigration subject is what's driving. It's just the preservation of executive power that drives a lot of the decision making, and it happens to be, immigration in this case. It could be environmental or whatever the issue is in the next case on there. So I don't know that I'll give the administration the benefit of the doubt that they're not just being anti-immigrant, they're being pro-executive power, and that's driving things. But I don't know. It may also be that they're getting a lot of internal agency pressure, which a lot of times, the politicians end up getting, unfortunately, I think, kind of mowed over by some of the voices in the agencies, the career people in the agencies that, despite the fact that they're not appointed, do seem to have agendas on there that some,
Well, I have to tell you, the Trump administration did a good job of blowing off all those agenda people inside the agency. They just ignored them. It'd be nice for Biden to do the same thing in this particular case. So we've got that. We talked about Gomez, Acker, that same problem, and just, stop.
Chuck, I don't know if you're going to mention Kinsley, even though the case is done.
Hold on.
We won the case, but a lot of people saw happy news yesterday. I think we should at least mention that.
Hold on, Greg. Let me just say one more thing about Go before you move on to that. I'm starting to get more emails from Go plaintiffs, and maybe the two of you are as well. Yeah. And I want to reiterate what we've communicated to people previously, which is, at this juncture, we cannot assist you in individual decisions about how to try to maximize your chances of getting one of those reserved visas. That's something you either need to do on your own, or you can hire a lawyer outside of the impact team to assist you in that. But we cannot give advice on that.
We are Switzerland as far as how they distribute to our plaintiffs. We can't advocate for anything that would help one group over another group of our plaintiffs. So hopefully you guys understand that. But I haven't gotten that many of those messages lately. I don't know.
They've been starting to pick up for me
every day. I get them every day. All right, just mention Kinsley because we won.
Yes.
And the borders are open, kind of.
Yeah, and the fruit of that labor was just a lot of people saw yesterday on television that the new, how many suits did we sue on this issue successfully?
Oh my God, it was just so many. I think it was like 7 different.
Yeah, there was like one of them wasn't our suit, but almost all of them were.
Yeah.
And that, the court ruled that these bans, that not travel bans in general, but visa bans were illegal. We won on that issue, and that wasn't the only reason why folks were able to get into the country starting yesterday, but the writing certainly was on the wall that the administration was going to have to end that policy, and I think that that this litigation was a help to that. So I'm really happy that we ended up pursuing those cases.
And Aaron, remind me, didn't Judge Maida rule that the current prioritization by the Department of State is also illegal?
Oh yeah, he did the tier 4 prioritization, but he limited it because these were the only plaintiffs before him. He limited it to DV 2021.
Right.
So what has Department of State done? They said, well, you didn't say anything about DV 2022. And it's just the same thing they keep doing over and over again. Basically saying we're not going to lift a finger to comply with the law unless we're sued. So we'll see how these numbers kind of start coming out in 2022, but I'm concerned.
I just don't get it. As far as our K1 cases, we have K1 Rio, K1 Manila, K1 Moscow, K1 London. We're just still waiting for each of the 4 different judges. It's not one judge sitting on it. It's 4 different judges, each sitting on a fully briefed this case, and we have withdrawn our plaintiffs that have gotten their visa. Judge Maida was only one of 2. We do have Judge Maida in one of these cases. He quickly, boom, he dismissed those people, and then one of the other judges, truly the judges never did anything. They just got, okay, they're dismissed. So it's like, it's not really anything more we can do.
No, London and Manila seem to be moving cases along.
Well, Manila's not moving is the problem. They've actually gotten slower since July.
Well, we're still seeing. I mean, I'm seeing the emails that are coming in every day from plaintiffs that are reporting they're getting interviews, and we had somebody got a visa this morning on there. So it's definitely picked up over what had happened in Manila. I understand a lot of people are still waiting, but it's an improvement on there. We're not seeing that in Rio, and we're not seeing that in Moscow. I guess we'll see what happens with these cases being moved to Warsaw. But for a while it was just London. Manila seems to be improving, and we're obviously going to talk to our DOJ folks and see if we can get any forward movement on the other ones.
Okay, we'll follow up with them. All right, on the H-1B lottery abuse case, once again, we're waiting on Judge McFadden to make a decision about, do we get to proceed or we have to refile the case? So that's kind of where we are. Greg, you did find something interesting on a listserv this morning about H-1Bs, particularly those in India, another area of abuse occurring.
Oh my God.
At the end.
I'm curious, as you guys can post about it in the comments or on Twitter, but there's a phenomenon that's happening in India. I don't know if it's in other places where people can't get appointments online, and there seems to be a black market for appointments. That there's some kind of the way, and it's probably with cooperation of insiders in the consulate, where people are paying and getting appointments to these agents, which is total corruption, and probably if they figure it out, someone will go to jail. But that's something that apparently state is aware of, and I don't know if they figure, and from what we can tell, they haven't figured out a way to address it yet. But it is something that we're hearing about. I don't know if there's any media, that's watching us, but
Lubna, where are you?
Lubna, it's really bad that might be happening. I mean, that's one of the things I think that are, we've never, of all the stuff that we criticize state about, and if you go back and look at all these recordings and all that, we never talk about the or accuse state of being corrupt or being dishonest or anything like that. They may be not competent, but in terms of what they're doing, but dishonesty has never been something that this I think puts a stain on the agency. They need to address this very quickly and very forcefully. Of course, in our discussions, we were saying that the only reason this black market exists is because the agency has utterly failed to be able to, issue appointments in a normal fashion and get their cases moving. So it's not a total shock that this is happening, but it is nevertheless something that is very disturbing in my view.
It was the nature of whore's a vacuum, it's going to fill that up. So that's kind of where we are for H-1B lottery abuse. And we, obviously, as we said before, if the judge dismisses it, we're going to refile it. And we'll go from there. We do have our H-1B lottery litigation case that is still out there that we're pursuing. We do believe that the Department of Labor is going to republish some rules, but we just don't know when. And we just want to make sure we stop this rule because it's really, really bad. Let's take some questions here, guys. We got a few questions. We actually had kind of addressed this already. The government appeal, I guess Aaron pointed out, in the Good Luck case for the preliminary injunction was due yesterday, I guess. But ours is not due until technically the 29th, right, Aaron? 60 days is the 29th. Yeah. So, but the 29th, what day of the week is the 29th? You always have to look at what day of the week something is. 29th is a Monday, so look for that Monday after the Thanksgiving holiday. Let's see, Federico. Good morning. Thank you for doing your EADs. Time frame. All right, Aaron, you want to talk about time frame?
Sure. The government has 60 days to file an answer to our complaint. In between now and then, we'll start communicating and basically saying, hey, look at our complaint, look at what you've done, and let us know if you really want to go into court and defend this, or if we should start negotiating a settlement that'll work for everybody. So I don't know what the time frame on any negotiations might be, but their first deadline is 60 days from the date of service, which will be today.
Our hope in all these cases is that we get, a reasonable government on the other side, and we can work out something quickly and settle for something that will be beneficial to our plaintiffs. And that's the case here as well. I mean, our preference is not to have to go, take this litigation to the end. Our preference is to get a solution quickly for you guys so you can get your EADs.
So case was assigned to Judge Leon in the DC Circuit, DC District. He is a senior judge. He's been a judge since, oddly enough, cute factoid, he was nominated to be a judge on September 10th, 2001. And thus he didn't have a hearing until February on his nomination. But he became a senior judge in 2016. He's a Harvard grad. He is the one that just shut down Trump's CBP's policy for CBP to be interviewing asylum seekers with using the excellent word, which is not used nearly enough in modern language, poppycock, when describing the CBP officers' preparation to be able to do asylum interviews. So we'll see. We'll see.
I think, I think the bottom line is that, sometimes people think in these cases, if you get a appointment of, one administration, that your judge is going to rule one way, and it's going to be different if you get a judge appointed by a different president. This is a good example of a judge who, I think is proven through his decisions that he's not, wearing partisan blinders, and is not able, and can make a decision that's favorable to immigrants, even though people perceive now that Republicans Republican appointed judges are always against you.
He was a different kind of Republican appointed judge. There was a different era, a different time. He also, Greg, you found this in his Wikipedia page. Who did he work for as a young lawyer?
Oh, he was an INS attorney. I was way back in the day. Although
that was very different in the
70s.
Yeah, that was very
different era. And also INS back in the 70s. We don't know what he was doing for INS because there was one age. The USCIS, ICE, and CBP were all one agency.
The attorneys back in the 70s were generally naturalization officers.
Yeah.
So they would do naturalization interviews. Our good friend Carl Schusterman was somebody who did that for a very, very long time. Joe thinks this is a good time for a live. We agree. We'll probably go to a noon time for our lives, only because it's just easier for everybody here. It was just better when we were working
for my biking schedule in the winter.
Yes. Yeah, absolutely. So then we like to do it in the daytime. It's kind of nice. We talked about the DB 2021 earlier in the show. You can talk about that. We talked about the appeal there. Somebody did ask this question. We don't know the numbers. We're not number guys. We went to law school, not math school. I just don't know what it means that you're 13,000. I just don't know what that means in the context of law. You know who does know though? Britt Simon.
Yeah,
so,
he's here. He was here. I don't know if he's still here.
Britt Simon says, go to Britt, and he'll tell you what to do, what that means. Federico, already asked that. You only have to ask once. Lukash, good to see you as well. Let's see. Simon Paul, who actually, they got to appeal just 46 days. There you go. And I think that is Britt Simon, by the way, right there. That's Simon Paul. I think that's exactly I think. We've got, good morning, ED case 6, only relief for a certain category. All right. Well, Mayank, we talked about this earlier on. There is another lawsuit about to settle that solves the H4 EAD conundrum.
Well, and also we have it's not just E2s. The much bigger group are adjustment of status.
Adjustment of status applicants, and we'll be adding anybody else that wants to be part of the appointment.
Yeah, I mean, if you're not in the only two groups that are not in here deliberately are L2s and H4s because they're covered in the other litigation. But anybody in any and the H4s, stay tuned. There will be news on that this week.
Now, one thing I do want to point out: the H4 EADs in that case are extensions.
Yeah, not initials.
Not new H4 EADs. So that's a different kind of scenario. But basically, they're going to make H4 extensions automatic. So you just keep working. Valid's good till you're done. What I think they'll probably do. But they're going to have to figure out how to get the H4 EADs done. But Mayank, the reason H4s are not incident to status is because they're not incident to status. L2s and E2s are created by statute as EADs, whereas the H4 is a creature of regulation by the Obama administration. So,
yeah, I mean, we'll see what happens this week on the H4s and L2s in terms of the announcements we're expecting, and if it's not what we're expecting, we still have an opportunity to make amendments.
Britt does ask a question: would they have appealed September 9th order just to keep options open for December 30th? Well, they have to appeal the preliminary injunction because that is the key part of that case. That's where all, that's the focus of the ruling. That's where all the logic is, and that's why they had to file that and get it done at that point. And Britt's right. Go Congress. Greg, is there any update on Plan C and the $100 million?
There has actually. This was a very interesting week on legislation. So everybody probably read a bit in the paper about the big $1 trillion infrastructure bill that passed on Friday. So there was all kinds of political drama on Friday immigration was a key part of that. That wasn't the only driving thing in it. But basically what happened is the House had the House, there's two bills. There's the roads bill that just passed, and then there's the human infrastructure bill, is what they're calling the BBB bill, the Build Back Better. And that bill, the infrastructure bill, had already passed the Senate months ago, and it was being held up in the House because the feeling was if they pass that bill, they're going to lose a lot of leverage on getting the bill that the progressives in the Democratic Party really want. And so they were basically, the decision made was that they were going to pursue both at the same time. And that was actually what was going to happen on Friday. They were going to have votes on both of those bills. But at the last moment, a group of 6 centrist Democrats said they were wanting to see what they call the CBO score, the Congressional Budget Office score, on what impact this bill was going to have on the budget deficit. And that was most of that was already known because they've had it, but there had been a few changes where there were some unknowns, and some of the tax stuff had been changing at the last second on how they were going to pay for these provisions. So they were obstinate about not having that vote without that score, and the progressives we're not doing the vote on the other thing if we don't have this, if you're not moving both at the same time. And after a lot of strong arming and the president calling people's mothers, and he actually did call Pramila's mother in India too, but they ended up, the deal that they made in the House was that they voted on the infrastructure bill. I don't know if the president signed that already. If he hasn't, there'll be a big ceremony for that.
I think that's today or tomorrow.
Yeah, so it's a great bill, so I can't really say anything.
I'm grateful for my farm in rural Tennessee.
I know, as a bike rider, I'm like, this is like the best thing in my entire life. But they passed a preliminary vote on the other bill with the immigration provisions in there. So we talked about it last time, what the provisions were that were in there. There's a parole in place provision, which will benefit, I've heard 7 million people. It's a really broad provision. And then all the backlog reduction stuff is in there, including what we just talked about with DV and reclaiming, I think David Beer was saying like 500,000. I mean, some huge number.
Oh, it's got to be. It's got to be
of green cards that are going to be added back in for family and employment, plus early adjustments, plus being able to pay a tax and getting around quotas altogether if you're subject to it. So all that's in the House bill. Now, what the deal was is that they reached at the end is with respect to the CBO scores, they will probably they're out of session this week, both the House and the Senate. CBO, I'm sure, is furiously working on getting them whatever they want, but they did commit to doing a vote before November 15th. So that's next Monday, I believe, the 15th. So that will happen there. Now, on the Senate side, the parliamentarian, they held it up for a while, but my understanding was that they had presented not the parole language, not the rest of the language, just the parole language to the parliamentarian to get a read from her on that. I wouldn't worry too much about, a lot of people are saying, well, it's like, why aren't they presenting the backlog reduction stuff and all that? And the House bill is going, if she's okay with that, the House bill already is going to have all that stuff in there. So the parliamentarian, one way or the other, is going to probably opine on that language, because the Republicans are not going to just let that language go without arguing that whole section should be stripped out. What I think will be interesting is if the parliamentarian doesn't give a favorable opinion, which I'm frankly not super optimistic that she has it in her to bless anything.
You're not optimistic? Then we got problems.
So then the question is, well, the Democrats do have, I mean, this is the part that they're really playing down, is this parliamentarian is just, it's an advisory opinion. That's all it is. So if they just decide to take the House bill up, then the way it would work is there'll be an amendment process, but so some of it will be changing, and it will have to go back to the House on the other side. But on the immigration provisions that are in there, someone is going to have to raise an objection and to the language, and for it to be stripped out of there because it doesn't comply with this Byrd rule, they need 60 votes on there. They do not have 60 votes to kill the immigration language. Joe Manchin, Kristen Sinema, they may vote against that language, but it would still stay in. Now, the question is that, they're pretty persnickety, Sinema and Manchin, and would they vote against the final bill on that issue? I don't think both of them personally have said they're okay with the language. So they don't have a philosophical problem. It's really a process question. And the issue is whether they, I'm optimistic that they would be fine with being able to vote no on the motion and still at the end of the day vote for the bill, saying that they got their say and that they wouldn't kill this whole bill over a process question like that. But I don't know on there. They've optimisted me.
Well, Greg, you said they're on vacation this week. So basically, if they're going to vote by November 15th, they're voting on November 15th.
Well, the House is voting on November 15th. The Senate, I don't think will vote. The Senate's going to take several days on the floor, I think. Because
I understand the Senate could take till December.
Yeah. Well, they have a hard deadline of December 3rd.
Well, I think it's December 10th now, actually.
As far as so here's the thing. There's two other things that are coming up that factor into this. And I don't know if they're going to get any reconciliation or not. But one is the government is scheduled to shut down again. I think that's December 3rd. And then they're also the debt default issue comes up again in a couple of weeks. So there's some earth-shattering financial disaster stuff that's coming if they don't get this stuff done by early December.
Hey, there's one thing I forgot to mention earlier today. As all of our Chakrabarti plaintiffs know, the Judge Massett moved us out of Maryland today at 2:00. If you recall, there was like 15 lawyers on the call with Judge Massett, but we were the ones he sent out first, because we had a deadline. The rest of them are actually getting oral argument today, and our good friend Ron Klasko is arguing.
Yeah, and I'm glad you mentioned that because we're doing this call now on Tuesday during my normal Facebook Live call, and Ron's arguments are exactly during my normal Facebook Live. I'm not doing Facebook Live today, so I apologize.
This is good enough.
I have no announcement for that, but it will be back next week.
Now, here's something that alerts us, because we told everybody, look, we're going to wait and see what the first quarter numbers look like.
Yeah.
And Britt Simon's telling us it looks like you're screwed and you're going to be suing them. So we'll probably get moving here on something on the webpage to begin collecting plaintiffs that want to move forward. Again, it's wise to have ammunition. It's wise to be fully loaded for bear before you go hunting for the bear.
We'll start working on getting that ready for onboarding. We just don't want to start collecting, for plaintiffs in that case until we're pretty sure we're going to sue.
Now, this is another thing. Britt was right about this. They did stop processing again, because I think, what is there, 5 people that work at the KCC? Is that what they told us? Was 5 that work there? And I forget. It seemed like they said there was 5 people. So they had to, switch back and forth. There's a little Dutch boy sticking his finger in the dike. Heaven forbid you should hire some temporary. Oh, speaking of temporary help, Greg, yesterday I posted and I pointed out to you that the Department of State put something in the Federal Register about their database.
Yeah.
About their documents and about all your images and your applications. And they admitted they're all available online to their employees.
Yeah. And they have all sorts of cybersecurity in place to prevent the parade of horribles that they were saying previously was the reason why they weren't letting people work from home.
So when we do sue them again and they complain about COVID, we'll say, Judge, according to what they published in the Federal Register, they could just do this from home. It's really that simple. Let's see. Do you think the ruling, I think there's some movement? We've been off with limbo. Is this a little case? Oh, I think Danielle's talking about the K1s. I think it's important to stay in the case because that keeps pressure on the government. They know that you're there. They know you're a plaintiff. And I think that's important. I think that has helped at least some people move forward faster than I normally have done so.
They still are working through this. I don't know what it is, 600,000, 700,000 backlog on there. And I think that that people could be waiting several years for visas if things just work themselves out in their normal way. So that's not a pleasant thing to think about, but that's unfortunately, I don't know how they catch up unless they start making some dramatic changes other than litigating.
Aaron, Eli wants to know if the Good Luck Reserve visas are in danger.
I mean, if they lose the appeal.
Yeah, I mean, it's hard to say. I think Judge Mehta's decision is solid, on solid ground. So, I think they're in good ground. But yeah, that's what's on appeal.
Yeah, I mean, I guess that they. One question would be on that, even while it's on appeal, if it's not stayed the order, whether the judge will put some pressure on them to start actually issuing these visas.
Andre makes a good point, Aaron, that in the Good Luck decision, decision includes Tier 4 discussion. And they want to, he says they want to kill the precedent to stop potential claims from DB22. Well, here's the thing. First of all, even if when they appeal, that's going to take a year. I mean, that is a slow process. I mean, there's no reason to expedite it as far as the court's concerned. So I don't think it helps them if that they appealed it for DB 2022. So I think we're okay there. I think that'll do it for today, guys. It is awesome to see you on a noon, 11 and 10 a.m. From different time zones around the United States. And we'll be back. Maybe we'll figure out a time that's good for us considering our other Facebook Lives that we do on our individual firms. But I think we like this morning, midday live rather than the evening one when we could be hangry. I need to get home to eat. All right, everybody, have a great day. Bye-bye.